Are non-provisional patent applications expensive to file? If you are curious about the costs associated with filing a non-provisional patent application, you are in the right place. Let's break down the expenses involved in this process. First, a non-provisional patent application is the formal request submitted to the United States Patent and Trademark Office to obtain enforceable patent rights. This application is more detailed than a provisional application and requires a comprehensive description of the invention, claims that define the protection sought, and formal documentation. Now, when it comes to costs, the United States Patent and Trademark Office filing fees can vary based on the size of the applicant entity. There are 3 categories: micro, small, and large entities. For instance, basic filing fees can be around $70 for micro entities and $300 for large entities. However, those fees are just the beginning. In addition to the basic filing fees, there are other costs to consider. These include search fees, examination fees, excess claims fees, and issue fees. Altogether, these fees can add up to over $1,000. The issue fees alone can range from $258 to $1,290, depending on the size of the entity. One of the most significant costs comes from attorney fees. Preparing a non-provisional patent application often requires legal expertise to draft claims and specifications that meet strict requirements. Attorney costs for drafting and prosecuting a patent application typically range from $5,000 to over $15,000. The complexity of the invention and the number of claims can greatly impact this cost. For example, a relatively simple application with about 10 claims and a 10-page specification might cost around $8,500. In contrast, more complex inventions, such as those in biotechnology or mechanical engineering, can cost between $11,000 and $15,000 or even more. Additionally, there may be costs for patentability searches before filing, which can range from $1,500 to $4,000. After the patent is granted, maintenance fees are also necessary to keep the patent in force. From a patent law perspective, these costs reflected the importance of properly filing a non-provisional application to secure enforceable rights. The investment in filing is justified by the legal protection it provides, allowing the patent holder to exclude others from making, using, or selling the invention for a limited time. In summary, filing a non-provisional patent application can indeed be expensive due to the various fees and professional legal services involved. Total costs often range from several $1,000s to tens of thousands of dollars, depending on the complexity of the invention and the size of the applicant entity. This expense is an essential factor to consider for inventors and businesses planning their patent strategy and budgeting.